Monday to Friday at 12:30 p.m. only on Bloomberg Quint.
Hello and welcome to Bloomberg Quint. You're watching the Fineprint. Giving home buyers a seat at the creditors' table, expanding the pool of potential bidders, making recoveries easier for lenders, and expediting decision-making by the creditors committee by lowering the voting threshold. The 14-member Insolvency Law Committee has made several suggestions to address the gaps in the Insolvency and Bankruptcy Code. If the committee's recommendations are accepted, this will be the third round of amendment that the Insolvency Code will go through after being in force for a little over a year. The Fineprint spoke with experts on the committee's top 5 suggestions and whether they will ensure a smoother functioning of the code. The home buyers in projects of Amrapali Group and JP Infra have been fighting for their claims against the insolvent companies. So far, they have found a sympathetic ear in the Supreme Court that has recognized the disadvantageous position of home buyers. Disadvantageous because the Insolvency Code doesn't recognize home buyers as a category that gets to have a say in the resolution of the company. They can only submit a form for their claims and hope that the resolution plan approved by the creditors committee will settle them. This will change if the government accepts the proposal of the Insolvency Committee to treat home buyers as financial creditors. If recognized as financial creditors, home buyers will get representation on creditors committee, and in the event of liquidation, they will be entitled to get their dues as per the credit hierarchy.
Yes, they should be included as financial creditors. For this, we need to understand how financing or how a home is bought by a customer. So when the developer starts the project, he raises money to buy the land on his own because that's not supposed to be funded by banks. So that is through equity. He then raises construction finance, which is essentially working capital, to start the project. And then he starts selling flats to various customers like you and me. And these people who buy these flats either take home loans or they fund it through their own equity. Now, essentially what they are doing is that they are replacing the existing lender who is the project financier. So, they are in effect the new borrower into the company. So they are financial creditors too to the project.
Whether you're secured or not can't be deemed fiction. Yeah. It could have been a sort of a lien which you carve out regulatorily, like we used to do when we had the various state laws which completely disturbed the pecking order in a dissolution of a firm in the Companies Act. You could create those deemed liens, but it would always be a question of fact. I mean, if you're a secured creditor, you would file for it. The securities would be filed under the Companies Act. And of course, now you have the information utilities. So it's really a question of fact whether someone is secured or not. You can structure a home buying agreement in very many different ways. It's not necessary that one size should fit all. A sophisticated home buyer could well have security. Who knows?
The committee hasn't just stopped at suggesting inclusion of home buyers as financial creditors. It has recommended that any company that has large number of creditors, for instance, security holders such as debenture trustees, fixed deposit holders, and all other classes of financial creditors which exceed a certain number, should be allowed to initiate insolvency proceedings and get a seat at the creditors committee table. The second important suggestion relates to widening the pool of potential bidders. And this, the committee has suggested, should be done by amending Section 29A of the Insolvency and Bankruptcy Code that lays down the ineligibility criteria for submitting a resolution plan. The ineligibility criteria also applies to any person acting jointly or in concert with an ineligible person. The same section also bars connected persons from submitting a resolution plan. But it's not clear whether connected persons to the ineligible resolution applicant are barred, or even those who are acting jointly or in concert with an ineligible person. The committee has pointed out that the latter interpretation would bar multiple layers of persons who are even remotely related to a resolution applicant. This may shrink the pool of resolution applicants, and so the committee has suggested that persons acting jointly or in concert in the section should be deleted.
There's been enough deliberation. It's not like the Banking Law Reform Committee sat over a period of 8 or 9 months and came out with the code. I think they chose the design philosophy after very long deliberations. There is no need for you to firstly bar the promoters. If you've actually adopted an administrator-led regime, then wait for the market to settle down. Surely the Committee of Creditors have the sophistication, or will develop the sophistication, to finally understand how the systems needs to play out. So I didn't see why you had to react, and the lawmakers reacted with express speed. The resolution plan was adopted sometime in August, I think, and then you had the IBBI coming out with declaration of preferred transactions ought to be there, and liquidation value ought to be confidential because they found that bidders were gaming the system, and then they found the promoters might be gaming the system. But the whole bankruptcy code itself is a game that you need to play out depending on how your economic interests are aligned. So philosophically, I didn't think firstly there should have been a bar like the one we have in 29A. Why don't you then just go and choose a different regime? Just wait for the courts to create a special bankruptcy code like the US system. And now you backpedal. You come back and say, okay, let's just take out such other persons acting in concert. And then you go and widen the connected party definition. Where is this all leading to?
No, this was required because there's no definition, persons acting in concert and connected is a very, very wide scope. So under even SEBI guidelines, the definition of persons acting in concert is a very wide ramifications. So therefore, for instance, even if I as a financial institution have, sponsored or financed a project, and that project has, God forbid, got into some financial difficulties, therefore I also am a connected person, so therefore I get it disqualified. So therefore, at this rate, we will have nobody who will be bidding for assets at all, who will be qualified or eligible to bid. So therefore, I think this is a very good step.
But interestingly, at the same time, the committee has suggested that the definition of connected persons be expanded. Currently, anyone connected to an ineligible person cannot submit a resolution plan. Connected person is defined as any person who is the promoter in the management or control of the resolution applicant, or any person who shall be the promoter in management or control of the business of the corporate debtor during the implementation of the resolution plan, or the holding subsidiary or associate company or any related party. The committee has suggested an addition here to cover persons who act with a common objective along with the resolution applicant to acquire shares, voting rights, or control of the corporate debtor.
Yeah, this will lead to a huge interpretational mess. Also remember the fact that related party is now to be interpreted organically in accordance with the Companies Act. If you look at those definitions, this is bound to create a lawyer's paradise. We're going to have huge amount of jurisprudence on this in trying to figure out exactly what these words mean and how they fit the specific facts and circumstances. Facts and circumstances are going to be a key driver in how each one of these words or these phrases are going to be interpreted. If you look at the way it's been drafted, it could mean anything, especially informal. What do you really mean by informal? So you have no way of knowing that. I mean, if it's a family-driven business, then who are you more accustomed to take orders from? What kind of agreement would you have in a proprietor-driven business like in the Indian circumstances? If you had a dinner table conversation, does that become sum and substance of the interpretation here? How are you going to even figure out?
The fourth important suggestion of the committee relates to withdrawal of an insolvency application after it has been admitted. Currently, the insolvency law doesn't envisage a situation where an insolvency application can be withdrawn once it has been admitted. To address such a situation, the committee has suggested that withdrawal of insolvency application post-admission should be permitted if the creditors committee approves of such action with a vote share of 90%. But it's not clear till what stage of the insolvency process can the creditors committee exercise this power.
I think the provision which sort of has been made for withdrawal of IBC proceedings based on settlement with 90% approval of the Committee of Creditors, I think it's something which should be reconsidered. The IBC itself is a measure which operates more as a threat and discipline rather than the outcome itself. The fact that the IBC is an irreversible process is one of the main features of the code itself. Now, if you provide for a settlement of a particular case with a corporate debtor with 90% vote of the Committee of Creditors, I think you're diluting the impact of the IBC in some way. It sort of upsets the process which has been started, and which, if it is taken to the logical end, would probably realize a better outcome. In many of these cases, the certainty of the process is equally important rather than just the outcome. By providing for a settlement with the corporate debtor with 90% consent, I think we are compromising one of the key objectives of the code. I think this is something which should be reconsidered, because today you will have people who will be willing to participate in the process on the basis that it is a certain process and there will be a transparent process and there will be an outcome. Regardless of what the outcome will be, there must be an outcome. But if you provide for a settlement based on 90% approval or whatever that percentage may be, I think it introduces a lot of uncertainty in the IBC process itself. For example, based on the people can use IBC as a price discovery to come up with a settlement proposal for the banks, and and it will just deter the bidding process for people to come and participate. It almost becomes like it can become like a right of first refusal for the existing promoter, subject to they not being tainted. So I would, in my view, this is a proposal which needs reconsideration.
When do you stop that cycle, the washing machine cycle, so to speak? It should be at any time when the COC is able to decide. And the COC says, no, we are bleeding too much in terms of working capital. We're not getting interim finance. We have the option to go in for liquidation. This process is linear. Once you get into insolvency, you can go to liquidation anytime. So I think timing here is more an economic question as to how the finances are going to be arranged and who's suffering more, and whether there is disproportionate decrease in the value of the business with every passing day. You might have a business which has very well arranged working finance capital arrangements, and that could run for a couple of months more. On the other hand, you might have a very time sensitive business. So I didn't think there was any point in figuring out at what stage you could terminate this process.
The final suggestion has to do with one of the most litigious area under the Insolvency Code, where the creditors can invoke personal or corporate guarantees when insolvency proceedings have started against the corporate debtor. Here, the committee has suggested that contractual principles of guarantee must be respected and the moratorium should not be extended to guarantors, meaning creditors should not be barred from invoking guarantees given by promoters or holding companies of the company facing insolvency proceedings. This because the guarantor's assets are separate from those of the corporate debtor, and proceedings against the corporate debtor may not be seriously impacted by actions against guarantors.
Yeah, I think the IBC itself is quite clear that the moratorium does not extend to any proceedings against the guarantor. And if you had looked at the wording in the earlier SICA, there was wording to say that proceedings against in respect of enforceability of guarantees were also covered by the section 22 of SICA. So that is absent in the IBC as it currently stands. So I concur that no change is required for this, and that's the principle that moratorium should only apply to the corporate debtor and not to the guarantor. It's a matter of fact that there are divergent views, and hopefully with the reiteration by the committee, the appellate authorities and eventually the Supreme Court will take the correct sort of position that moratorium should be restricted only to the corporate debtor and not the guarantor.
Well, these were the top 5, but there are several other important changes that the committee has suggested to lower the creditors committee approval threshold from 75 to 66%, apply the Limitation Act to the Insolvency Code to not give a fresh lease of life to debts which have become time-barred, and exclude regulated financial creditors from the applicability of related parties if they become so as a result of conversion of debt to equity. We'll have to wait and see how many of these make the cut. Moving on, there's a new revenue recognition standard on the block that India Inc. should prepare for. Just a few days before the beginning of this financial year, the Ministry of Corporate Affairs notified Indian Accounting Standard 115 that will impact the way companies recognize revenue from contracts with their customers. I spoke with Deloitte India Chairman PR Ramesh on what companies need to do to prepare for this new standard and the kind of contracts that will be impacted. I began by asking him the gaps in the existing standards that prompted the introduction of a new one.
The existing standards had limitations in terms of addressing all the developments in the business models which arose since the last 10 years maybe. The second is there was additional guidance in the form of interpretations, for example, customer loyalty programs, real estate transactions, which were not in those two standards but in the form of interpretations. This one standard now combines not only the two standards, combines all the interpretations and provides far more detailed guidance on the various scenarios, and therefore is extremely comprehensive compared to what the earlier one was.
Okay.
Though dramatically the principles may not have changed significantly, but in its application to situations there would be differences.
Okay, so this is called revenue from contracts with customers and it has become effective April 1st. The objective of this standard is to establish the principles that companies should apply in terms of the nature, amount, timing and uncertainty of revenue and cash flows arising from a contract with customer. How will the way revenue is recognized going to change from now on?
It will change way forward depending on the nature of the contract, of course. Particularly, it will change, again, it also depends on the nature of the industry, but particularly it will change both the timing of the revenue and the quantum in some situations. For instance, this new contract has detailed guidance on how to recognize the revenue based on a 5-step approach. The 5-step approach is about identifying the contract, the various performance obligations in the contract, what's the transaction price, how do you allocate the transaction price, and when do you recognize the revenue, depending upon whether the performance is delivered at a point in time or over a period of time. Now, judgments are there, first in terms of what are the distinct performance obligations. A distinct performance obligation is where a customer is able to derive value from that obligation, or it is in a manner where customer can use that product or service together with other products or services the customer already has, or is able to use it independently. But if it is integrated with other elements in the contract, then it is not a distinct product or service, even though it's identified in the contract. Then the third element was the transaction price. This standard deals with the complexities arising out of identifying what's a transaction price. For instance, transaction price could be variable based on quantum, variable based on events which are likely to happen. If I may give you an example, supposing I say my selling price to you is 1,000, but if over the next 1 year you buy X quantity, you will get a rebate of 10%. Now, I will have to estimate the probability of your buying over the next 1 year that required quantity, in which case what I have sold to you currently at 1,000 is not 1,000 but 900. So that again is a result of estimation. And then you have the allocation, which itself is a complex thing. Supposing I have 3 products, each which I sell for 10, 10 and 10, and I price at 28. The question is, should I allocate the 28 in the ratio of 10, 10, 10? But what if I don't have a separate price of 10 for product C, for instance? How do I allocate? So there are rules, or rather guidance around how do you allocate the transaction price. And lastly, what I said is recognition of revenue. Once you've determined these obligations, is it an obligation at a point in time or over a period of time? Typically, you could have issues, let's say in licensing. I sell a license to you. Now, when I sell a license to you, is it a license which gives you a right of access or a right of use? Right of access means as I develop or improve my products, you will continuously have that access. Right of use means I've sold you something that you can use for a certain period or in perpetuity, not what I develop thereafter. So that will determine whether revenue should be at a point in time or over a period of time. So there are complexities. In each of these will impact the way revenue has been recognized in the past and what is current. And if I may add further complications, it provides far more detailed guidance in relation to customer loyalty programs. The issues of the term we use is break in customer loyalty or other programs. Break, for example, is I sell gift vouchers to you of 1,000 rupees each, I sell you 10 gift vouchers. You have 10,000 worth of gift vouchers. Now there is a high probability that you may not use one of those gift vouchers at all, even if the validity period is 1 year. So do I recognize 1,000 at a point, when I sold you, do I recognize 10,000? Or do I recognize as you use the gift voucher? Or do I factor in the probability that you may not use 1 out of the 1,000 of the 10 which I sold you, and recognize 9,000 over a certain period?
So it may lead to postponement of recognition of revenue and the quantum of it. Okay. Is it going to impact the real estate company significantly? Because
Sure,
as I understand, they were recognizing revenue on percentage of completion basis. That changes now?
Yes, it will change. It could change because, again, if you look at real estate today in India, real estate was accounted on the basis of the guidance note on real estate transactions issued by the institute. That had many other conditions in terms of testing for realizability, testing for completeness of the project over a certain size, and dealt with different scenarios. Now, what can change is one of the principal conditions in this standard, which talks about control of the asset being given to the customer. Right now. And the question of a point in time or over a period of time, a recognition of revenue will depend on some of these conditions. For instance, if I may give you an example, I have a piece of land. You as a contractor come and construct on my land or a piece. The land belongs to me. So whatever you construct, I have control of that asset as you construct. I can terminate my contract with you at any point in time and call somebody else to complete the construction, right? So if you were to account for it, maybe you will be able to account for over a period of time, because at any point in time as you're completing it, you are able to recognize the revenue. You can walk, I can throw you out, you can walk away, but get paid for what you've completed. Take the other situation. As I buy a flat in a building under construction. Now, I have no control of that flat till that flat is completed.
Handed over to me.
Now, from a builder's point of view, has he given control of the asset to me? No. Is the asset there at all? Perhaps no. Is it something that if he's partially, can I terminate the contract partially and walk away and say I will complete the rest of the building? I can't. I have only one flat in the building. So it could result in revenue recognition being different from how it is today.
Okay, so what should companies, since it was only notified in the last day of the last financial year, what sort of preparation would companies need to do to be able to recognize revenues based on this standard?
So companies need to do a few things. One is they need to look at all their existing contracts which are still live. They may need to look at past contracts which are not live, depending on which approach they follow as to what we call an approach where you would full retrospective, or a modified approach where you do only current open contracts and leave the past as it is. Now let's assume we do only current open contracts. Companies need to look at all those open contracts to see whether revenue should be recognized differently as opposed to how they've been doing. Second, they may wish to look at, in the new contracts, whether the contracts need to be redesigned so as to match the accounting to the economic benefits in the contract. Because at the end of the day, what any entity would like to do is whatever the economic activity which has resulted during the year should get reflected in the financial statements too. Otherwise, you find that you've done a lot of activity, but no revenue is shown, or it's not, there is a mismatch. So that is the second thing which they need to do. Third, perhaps what they need to do is, in light of all of these, whether their IT systems need to be tweaked, whether their performance metrics need to be revisited, how they reward employees for performance need to be recognized, because you could have incentive systems based on what's recorded in the accounts. So if your accounting measurements change, you'll find that the marketing function is doing the same work as it did in the previous year, but suddenly has less incentive payments because of the way accounting measures their work. That is another thing which they need to do. And of course, investor guidance.
There are certain disclosures as well that
yes,
the guidance mentions. Correct. Thanks again, sir, for taking us through the principles, the scope and applicability of the new revenue recognition standard. And thank you so much for watching. We'll see you next week.